and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to drop in on some of the most informed conversations you will hear on these topics. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Trial Practice Committee, the Antitrust Law Section. Today's episode is on the rise, fall, and fallout of the Federal Trade Commission's authority to obtain monetary remedies for consumers under Section 13B of the FTC Act. Injunction. What does that word mean? Is it a legal order that is limited to stopping bad conduct, or can it also affirmatively require actions to right the wrong that has occurred? When a bad actor cheats someone, our sense of justice and fair play demands not only that the bad actor get punished by the watchful authorities, but also that the victim be made whole again. This is the concept of restitution. As a matter of economic justice, it is meant to prevent the bad guys from keeping the money they stole and thereby profiting from their crimes in spite of getting caught. Section 13B of the Federal Trade Commission Act empowers the FTC to seek a permanent injunction in federal court against a party violating or about to violate any law that it enforces. But is that authority limited to stopping illegal activity, or does it also encompass disgorgement of illegally obtained profits? Certainly there is historical precedent for the word injunction to both prohibit and mandate conduct. Stretching back 2 centuries, we can point to precedents in English common law in the 18th and 19th centuries in which injunctive orders provided total satisfaction to the wronged party, including restorative monetary relief. More recently, the Supreme Court in 1946 in Porter v. Warner Holding Company held that absent a clear indication of contrary congressional intent, the equitable powers of a federal court include, quote, the recovery of that which has been illegally acquired. Section 13B was added to the FTC Act by Congress in the 1970s in response to concerns that Americans were getting ripped off through scams and frauds at a massive scale, and the federal government didn't have the power to do much about it. For decades afterwards, the FTC brought cases against unfair and deceptive acts and practices under 13B in which federal courts, time and again, authorized the FTC to make the defendants stop the bad behavior and disgorge the money they had wrongfully obtained. Yet, while other later sections of the Act explicitly give the Commission authority to seek other equitable remedies, the plain language of 13B only uses the word injunction. Finally, this issue of what exactly is meant by the word injunction in Section 13B made it all the way to the Supreme Court. It was a case about one word worth $1.2 billion. What the court decided and how it has impacted the Commission's monetary remedies authority is the subject of today's episode. Joining me today as my co-host is Rich Cunningham, a vice chair of the Advertising Disputes Litigation Committee. Rich is a partner at Kirkland & Ellis and, like everyone on today's episode, including myself, a proud alumnus of the Federal Trade Commission. Rich, great to have you on the show.
Thanks very much, Anant, and what a fantastic introduction to these issues. I'm delighted to be here and really excited about this conversation we're going to have today. Let me start by introducing everyone. I'm going to start with the Honorable Noah Phillips. He's a former FTC commissioner who recently left the agency and has rejoined Cravath, Swaine, and Moore as a partner and helped open the firm's DC office. Also, we've got Maneesha Mithal. She's a former assistant director of the FTC's Division of Privacy and Identity Protection, known as DPIP to those in the FTC community, and is now a partner at Wilson Sonsini. And finally, our last panelist is Ioana Gorecki. She's a former FTC staff attorney in the Division of Financial Practices and is now a special counsel with Kelley, Drye. I want to begin with just a couple of logistical matters that I think apply for myself and for everyone else. I want to note that we speak only for ourselves as individuals. We don't speak on behalf of our current firms, any of our clients, and certainly not the agency that we all used to work with. And finally, I want to just say a profound thank you, not only to our panelists, but also to Anant and the team that's helping us produce the podcast. Most listeners are probably familiar with FTC versus AMG, the matter that Anant very artfully introduced a moment ago. But Ioana, it would be helpful if you would mind orienting us in general with the matter and how it fits in with the FTC's broader enforcement program.
Sure. Thank you, Rich. So I was really excited to get invited to talk about AMG on this podcast because, as some may know, I was one of those poor souls litigating AMG for 3, 4, 5 years. I don't know. It felt like a long time. But basically, I joined the FTC in 2012, and about a week into being at the agency, I was put on this case that seemed very interesting called AMG. And so I have sort of it's a very bittersweet time in my life, right? It was such a fantastic case. We had a great team, litigated it through just about every angle, every motion, every issue that could possibly come up, and came to this fantastic result in the District of Nevada. But just to back up a little bit, so AMG was a case about an online payday lending operation. And as many of these payday lending operations do, it offered fairly low rates for fairly high interest. The interesting part, though, was that you signed up, you were told that you would get a certain amount of money, say $300, and you'd pay $90 at the end of 2 weeks for a total of $390. Well, if you took no further action, if you didn't do anything else to change the default payment program, what would happen is you wouldn't pay that $390 at the end of 2 weeks. The loan would roll over and you'd get charged another $90. So after another 2 weeks, again, if you took no action, the loan would roll over and you'd get charged another $90. And it sort of went on like this for about 10 periods. And in the end, if you really did nothing at all, you would end up paying around $975 on a $300 loan. And that's sort of the basics of what AMG was about. And then there are a lot of interesting aspects to it. For example, this was set up as a Native American tribal business, when in fact, as the evidence showed afterwards, it really was run by folks who were not affiliated with tribes and taking most of the profit. So a lot of really juicy, interesting stuff here. And I just to put a plug, there is a Netflix episode in the Dirty Money series. It's called Payday, and it really lays out all of the juicy, interesting details about the AMG case. But anyways, moving on from that, we litigated and got this fantastic nearly $1.3 billion judgment, which at that time was the highest litigated judgment the FTC had ever gotten. And then the case was appealed to the Ninth Circuit. And at the Ninth Circuit, the defendants challenged the FTC's ability to get money under Section 13B. It was really one of their main arguments. And at that time, it was really interesting because they were citing a bunch of law review articles. I mean, they couldn't cite cases, right? I mean, on the FTC side, we were citing case law. We were pointing to the law, 40 years, 30, 40, 50 years worth of precedent showing that Section 13B cases could get monetary relief. And we almost laughed internally, like, what is this? What's with this argument based on a variety of legal review articles? But, and we did squeak by with a favorable outcome in the Ninth Circuit, but the writing really was on the wall because 2 of the judges on the 3-judge panel wrote a concurrence that basically said, yes, we have decided the case in this way based on decades of precedent, but we really think that precedent should be reviewed. And of course, this was in 2018. The next year, in 2019, the Seventh Circuit came out the other way in the CBC case and basically rejected the FTC's 13B authority. And that created the circuit split that then led to the Supreme Court AMG decision.
And Ioana, for our listeners who may not be as familiar with the FTC Act, why did they bring it under Section 13B?
So I think, as you previewed in your introduction, Section 13B was really a very easy, a very direct way for the agency to go straight to court to prove its facts, get money back for consumers. The alternative is obviously the administrative process, but that one's a lot. There are a lot more steps. It's a lot more difficult to navigate. And so over the last few decades, 13B really has been the main vehicle, the main avenue for the FTC to get to take cases to court and to get money back for consumers. So it was sort of the no-brainer choice. That's what you did. That's what everything was brought under at that time.
Noah, was the Supreme Court's decision surprising to you?
The short answer is no. When Elena Kagan was going through her nominations process in front of the Senate Judiciary Committee, she had a famous line. And the line was, "We're all textualists now." If you look at how modern courts interact with statutes, they're very, very focused on the text. What does the statute say? And the structure. What does the language mean in light of other words in the statute and where it is located? Fundamentally and above all, those are the things that count for purposes of statutory interpretation. And while Ioana and her team were absolutely on the side of truth and justice and righteousness, the
Thanks,
question
Noah.
in AMG, absolutely. The question in AMG and the question in CBC is a strict statutory question. And when you look at the text and you look at the statute and you look at the remedies specifically provided in Section 19, right, which is a different provision that comes up at the same time, and it's got limitations, right, in terms of its scope. It has a statute of limitations. You see a contrast between the two. And so what Anant started with, the word injunction, is brought more clearly to light. It's not a purposive question. What goals was Congress trying to effectuate? It's what did they write down? So I think to look at the statute, the answer was fairly clear. And if you looked at what the judges were writing, even when they were going to follow the precedent, they seemed to think that the defendants in that case had a pretty good point.
Maneesha, what do you think? Do you share Noah's reaction?
I do in large part share Noah's reaction. I was at the FTC when this went up to the Supreme Court. And in my mind, I said, okay, this is a poster child case. The facts here could not be better for the FTC. We have an A-plus team. There's not going to be any mistakes in litigation. This is a great case to tee up and to take up. So from a case selection standpoint, this was a great case. But I think to Noah's point, I think we did see the writing on the wall. I think our attitude was hope for the best, but expect the worst. And I think what I was surprised at was that it was a 9-0 decision. But at the same time, I think at the staff level, we were prepared. We were trying to think of alternatives and what would happen in case we lost AMG and trying to figure out alternative ways to make consumers whole.
Maneesha, you mentioned that 9-0 aspect. I still remember listening to the oral argument, and Joe Marcus is up there in front of the court. And the first question, which comes from the Chief Justice, is about, counsel, this is not how we read law today, very much echoing what I was saying earlier. And you get a few more questions like that. And then it comes to Justice Sotomayor. And she says, well, counsel, I don't read law exactly the way my colleagues do. But even the way I read law, you don't win. And I thought, oi gewalt.
Yeah.
Well, Maneesha, you really previewed where we're headed next in our discussion. We've covered the rise of 13B, and Anant did that eloquently. We've now covered the fall, and now it's time to talk about the fallout. Obviously, the agency is loaded with clever, creative attorneys. That's how 13B received such an expansive interpretation prior to AMG. I'd like to pivot now and talk about the response initiatives the agency has taken to advance its enforcement program across privacy, consumer protection, data security, even antitrust. And I'd like to start with what you view as the most significant and impactful part of the agency's response to an existence post-AMG.
Yeah, I think the short answer to that is just how holistic the response has been. I think the FTC's attitude has been, let's look at these little nuggets in the FTC Act, and let's see how we could use those nuggets in ways that we haven't used them before. And so the agency really came up with a multi-pronged strategy to try to get money back to consumers and to get monetary relief against businesses to create deterrence. And I'm just going to tick off a list of 5 things that I think the agency did. And as our conversation progresses, I'm sure we'll drill down into them. So the first is using MAGMOS rulemaking. The agency said previously this was a cumbersome process. There hadn't been much success in issuing MAGMOS rules. This is not just your typical APA notice and comment rulemaking. There's a lot of bells and whistles and additional procedural steps. So I think the agency's thinking prior to AMG had been that this is kind of an obsolete tool. Well, the FTC really rejuvenated that tool after AMG because one of the things about a MAGMOS rule is that you can get civil penalties for violations. So I think that's the first prong. The second prong is this authority under the FTC Act that, again, hadn't been used for years. It used to be called synopsis authority, but in keeping with the rebranding image of the new FTC, they began to call it Notice of Penalty Offenses, or NOPOs for short. And this essentially is that if there is a litigated decision, you can send a copy of the litigated decision to companies engaged in similar activities and get civil penalties against them for future violations of an order, even if they weren't party to that original order. So that's number 2. Number 3, I think there was greater cooperation with states and other federal agencies. And this started before AMG with Equifax. So, for example, the FTC worked with the state AGs and the CFPB because those agencies had monetary remedies that the FTC didn't have. So that's number 3. Number 4 is use of Section 19. So Section 19 says that you can get monetary remedies for, number 1, rule violations. So they dusted off a lot of old rules to try to allege new rule violations to get money under Section 19. And number 2, if the conduct is dishonest or fraudulent. So if they're dishonest or fraudulent conduct, you can get monetary remedies for that as well. So that's Section 19. And then the final thing I would point out is that they have really engaged in an expansive reading of statutes. One example is ROSCA, and I know this will resonate with Noah. So in the MoviePass case, for example, the FTC said, well, there's unfair and deceptive practices here. It's not related to a subscription service, but it's part of the product itself. So we're going to use ROSCA to say, because ROSCA prohibits deception in negative option offerings, even though the deception is not related to the negative option offering, we're going to say that there was a violation of ROSCA here. So that opens up a whole new ability for the FTC to get civil penalties under ROSCA that they couldn't get under the FTC Act.
Maneesha, for those of us who aren't familiar with the abbreviation, what is ROSCA?
Sorry, it's the Restoring Online Shoppers Confidence Act. And that it basically requires for negative option subscription services, there has to be clear and conspicuous disclosures of the negative option nature. There has to be informed consent and an easy cancellation process.
Anant, I'm grateful you asked Maneesha what ROSCA stands for and not me. Noah, one of the items on Maneesha's list, number 1, is Magnuson-Moss rulemaking. There are a number of currently open rule processes going on at the agency.
Over 20.
I'm wondering how they're managing that. I mean, that is a huge lift, and really kudos to the agency for taking on such an ambitious agenda in that space. Which of the notices of proposed rulemaking or NPRMs are you following most closely, and do you think will be most impactful?
So I think, Rich, we're all wondering how they're doing this. This is an incredibly ambitious regulatory agenda that the agency has cut out for itself, and it covers a terrifically wide swath of kinds of business conduct. I think there are sort of what I would call bigger rulemakings and what I would call smaller rulemakings. So on the smaller side, you think of like the impersonation rule. You can't pretend to be the government, which is, to my mind, a fairly good characterization of the distinction between deceptive and non-deceptive business conduct. One of the things I wrote when that came out was, I really don't think that good businesses are going to get caught up in this because you should know not to do this when you set out. But some of the rules are quite a bit more far-reaching, far more complex, far more ambitious in terms of the interpretation of the statute than that, and also probably a lot more interesting to both of the business community, but also the public. So 2 that jump to mind. First, what I think might be the most popular effort of this FTC, the click to cancel rule. However you feel about the underlying legal structure, I think a lot of us live in a world of lots of negative options and quite a lift when it comes to cancellation. I remember when I went to cancel the New York Times, which I had signed up for online, you're not able to do that online. You have to call someone and so forth. So that's a frustration that I think Americans feel, and it wouldn't shock me, given the public reception, to see the agency try to push that one forward. But I think the one that looms largest in my mind is what the commission calls its commercial surveillance advance notice of proposed rulemaking, which is an incredibly expansive look at rules they might make for data security, for privacy purposes. It looks at employer-employee relationships. It looks at kids issues. It looks at all sorts of conduct in terms of the collection, the use, the sale of data about people. The one that I am watching above all, just because of its potential scope, is that one. The agency makes clear in that ANPRM, that advance notice of proposed rulemaking, that they may make multiple rules. So even though our number is over 20, and to be clear, that includes a couple of competition-related rules, but mostly MAGMOS, that one could flower into still more rules yet.
Maneesha, how about you? Are there any rulemakings that are on your radar that you're tracking closely?
I would echo what Noah said. I think the, quote, commercial surveillance rulemaking, and I put that in quotes because I think commercial surveillance is another one of those branding terms the FTC is now using.
Maneesha, you know how I feel about that term.
Yes, I do. I think that one looms pretty large. But let me make a timing point here. I think we are almost reaching the 1-year anniversary since that advance notice of proposed rulemaking came out, and we're not seeing anything suggesting that that is going to be done anytime soon. So I think that might be one where the clock might run out, because I think one of the things we saw in old MAGMOS rules in the 70s and 80s is that even though it took 5 to 7 years for the average MAGMOS rule to be finished, a lot of them just were abandoned because of changes in administrations. And so I suspect that something like that might happen here. I mean, I was looking at the impersonator rule, which, as Noah said, is completely uncontroversial from my perspective. And that took 8 months from the ANPRM to the NPRM stage. And so I'm just wondering how they're going to do this all. I also think that these rulemakings are taking away from some enforcement activity. So we've seen, I think the numbers are probably a lot smaller in terms of enforcement matters. And so I think we're seeing that as well. So, and I'm watching the same things Noah's watching, the negative option rulemaking, the privacy one. I think endorsements is another one that a lot of our clients care about. So those are some of the things we're watching.
That's an interesting point, because you only have so many staff resources that by taking on so many at once, you might be creating a logjam.
Absolutely. I mean, I think it will by definition have to divert resources from enforcement to these rulemakings. And if they're not going to become finalized, query whether that's the most effective use of the FTC's resources.
Maneesha, staying on rule enforcement for a moment, you mentioned a few minutes ago some expanding interpretations of rules that are already on the books, ROSC in particular. 2 questions for you. Are you seeing that anywhere else in the FTC's enforcement program? And what are the pitfalls for the agency as it tries to reinterpret or more expansively interpret rules that may have been conceptualized more narrowly in the past?
Yeah. So I think we're seeing, let me point to 2 examples. I think the first example is an expansive, I don't know that it's an expansive interpretation, but it's a little used interpretation of GLB, the Gramm-Leach-Bliley Act, which prohibits the use of pretexting in financial services, so pretending to be somebody's financial institution. And so the FTC, in a couple of recent cases, one just as recently as last week, used a provision in there that prohibits pretexting and would come with civil penalties. And they used it to apply to really any deceptive financial services practice. So any practice where a company lies or makes a misleading statement in order to get consumers' money, they shoehorn that into the pretexting provision. I don't know that that's what the provision was originally intended for, but I think that's an example of where the FTC really went back to its arsenal and said, hey, here's a tool we didn't use, yet let's use this. And I actually don't think that's going to get much pushback, because we're talking about people who are trying to use deceptive statements to take people's money. So I don't think that's going to get a lot of pushback. On the other end of the spectrum, my second example is the health breach notification rule. So that was enacted by Congress in 2009 to address the burgeoning practice of having personal health records. So I have my doctor's office information for my general practitioner and for my dermatologist and for my orthopedist. And I can have my own personal health record where I could just port the information based on my permission. So the whole idea was that was going to become a big thing. But a couple of years ago, the FTC said, hey, wait a minute, there's some language that we could use in the health breach notification rule to make it apply to any and all health apps and connected devices. And I do think that the reading there was a stretch. And I think the FTC put out a policy statement. It then brought a number of cases, now is looking at rulemaking. So some of these companies that they are looking at, the facts of those cases might be bad, but I think companies are going to start challenging this more. And we're talking about FTC resources. There's no split between enforcement and rulemaking. Now, if you add litigation on top of that, I think that's going to be a real stretch for the FTC. And courts are not always sympathetic these days to the FTC, as we saw in AMG, as we saw in Kachava, the most recent FTC privacy case. And so I think there's some real pitfalls to the FTC making these expansive interpretations.
Let's shift gears and move down the really helpful list you set out for us at the outset and talk a little bit about the penalty authority effort that the agency has embarked on. I love your thoughts on that. Could you summarize it for our listeners and talk a little bit about the 3,000 plus letters that have gone out?
Sure. So Maneesha very helpfully laid out sort of the initial requirements of this particular authority. So this is under Section 5M1B. And there are a few things that you have to have in place in order to trigger this authority. So first of all, you need a final FTC administrative order on the books. So that means you can't have a consent order. It can't be an order that a court issues. It has to be an order that has gone through the FTC's administrative process. And that order has to determine that certain practices are unfair and deceptive. All right, so once you have that order, you have to have another unrelated company that engages in those practices that were described in the order. And they have to do it with actual knowledge that those practices are unfair and deceptive. And only then, if you can make those showings, then you can apply the section and you can get penalty offenses for those first-time violations. And the general intent of the statute, this provision in the statute, makes sense. Congress really didn't want the FTC to have to litigate the same thing over and over and over and over, right? They didn't want to have 50 cases on the same exact topic and you just have to keep bringing it over and over and over. And so it makes sense. Once they've made a determination and they've determined that certain practices are unfair or deceptive, and you're on notice and know about those practices, you can be held liable for civil penalties if you engage in those practices. Now, based on the discussion that we've had so far, I think the listeners can probably start figuring out some problems here. The first one being that the FTC hasn't really relied on issuing cease and desist orders very much in the last decades. And part of that is because they've relied on Section 13B, right? It's a lot easier. You can go straight to court, you can make your case in front of a judge, you get your money, you get your redress for consumers, or you get your disgorgement from the company. And so there haven't been a lot of cease and desist orders on the books for the FTC to point to and rely on. There have been a handful here and there, but not that many. And so one of the biggest challenges now with the FTC sending out these notices of penalty offenses is that they're relying on cases that were decided 50, 60, 70, sometimes 80 years ago. I mean, these are really old cases, like sometimes from the 40s, from the 50s, from the 60s. And so it's difficult. I think what the agency is going to have a hard time showing is that the practices that they're trying to tackle today, which are really based in the digital economy, right? You've got online variations and endorsements and ratings and reviews and all of this stuff. You could have a really hard time showing that those practices are sufficiently similar to those old practices in those orders from the 40s and 50s. And so I think that's really going to be a big sticking point here, in addition to the fact that there aren't that many orders to rely on. But yes, this is as you mentioned, the agency has been very bold in this area. They've sent out over 3,000 letters in areas of endorsements, education, substantiation of claims, money-making opportunities, and all of these notices basically lay out these old orders and pull some general parameters, general principles from those findings and say, company, if you engage in these practices, which again, I'll mention are pretty general, you are now on notice that you could be subject to penalty offenses.
And if I could just add one thing to that, is that I think a lot of companies are going to fight back on the basis of this notice requirement. So is it really actual notice to send a letter, a form letter, to a kind of unmanned inbox? And so I think that's going to be another area of litigation potentially.
And the other thing is, and again, I sort of alluded to this, but even if you're seeing that and you're seeing the very general descriptions that they're putting there, right? They're giving you the cases, but then they're saying, we're putting you on notice that these things are illegal. And these things are very general things like don't misrepresent someone's experience with a product. Don't use an endorsement if they haven't used the product. There's just really very general principles, not specific practices that I think, again, if you're trying to draw parallels between, say, I don't know, one of the cases they refer to is a company that used burial vault guarantees, right? They used a guarantee about burial vaults made by an insurance company. And so that was from the 40s. And so you're trying to say the findings in that case are like what's happening here online with ratings and reviews. And I think it's just going to be a really big uphill battle to convince courts that those are the same practices.
Let's talk about Section 19 of the FTC Act, another one of the items on Maneesha's punch list. Noah, would you mind just giving a primer to our listeners for where Section 19 fits in and maybe talk a little bit about how often it came up when you were a commissioner?
So first of all, Section 19 did come up when I was a commissioner. But you're absolutely right, Rich. It really didn't come up as a matter of enforcement until after AMG. So I mentioned earlier the structure of the FTC Act, and in particular, the amendments that gave us 13B, which is what the court limited effectively in the AMG case, really just to injunctions. Section 19 is not so limited in terms of its remedies. It actually provides for, among other things, the restitution of what people have lost, the rescission of contracts. It provides for damages. It provides, critically, for money. But Section 19 has really three things about it that made it less attractive as an enforcement tool for so many years relative to 13B. One, and Ioana referred to this earlier, it requires you to go through a process. You have to issue the order. You have to go to federal court. That's number one. Number two, there's a limitations period associated with it. And number three, and critically, the conduct in question has to be dishonest or fraudulent, or at least what a reasonable person would understand to be dishonest or fraudulent. And maybe that colors a little bit in the unfairness space, but mostly it sounds to us like deception. And just to be clear, dishonesty and fraud are mens rea words. And as we all know, there's no mens rea for deception. So you're probably realistically talking about a series of courses of conduct very much on the minds of Congress, as Anant was explaining earlier, when they were thinking about scams and stuff like that. But if you're looking at today's FTC and going after, in particular, big companies that have a lot of lawyers that make sure things are mostly all right, and for conduct that isn't clearly deceptive in the way that a scam or a fraud or AMG was, there you're going to have real problems with that language. And that's sort of how Section 19 fits in here. It's definitely there. It's a clearly congressionally given tool to the agency, but it's bounded. And it's bounded in ways that are just not going to apply to a lot of the conduct at which the agency wants to go, especially these days.
So let me ask you this, Noah, because it's an experience that I'm gonna speculate that everybody on this podcast and many of our listeners have had. And that's if you're handling a matter for a client that is part of the way through the investigation stage at the FTC, and an issue comes up either because staff has raised it or because the client has asked about it as a possibility. Hey, what happens if we face a large demand from the commission for money and the only legal basis is Section 19? Is that something that an investigation respondent should take seriously?
It's a great question. Let me say the following. We've been talking over the course of this podcast already about a lot of really aggressive interpretations of statutes, right? A health breach notification violation where there's no breach. Right? That's one of the things the agency is looking at. At the very least, an interpretation of ROSCA that doesn't map the negative options in question. It's about deception as to the material terms of the underlying product, on and on. What most companies end up doing is settling these cases, even if there's a very good argument that the agency is over its skis as a legal matter. And I think the same principles are likely to apply. In fact, they probably have applied already if you look at the enforcement record in the context of Section 19. What the agency has here is something that isn't limited in the way that the rules and the specific statutes are in terms of its jurisdiction. And so they're going to look to Section 19 as a mechanism to get money in the cases where they don't have these other tools. They don't have Graham-Leach-Bliley or whatever. Maybe that's the wrong example, but they don't have ROSCA. They don't have health breach and so forth. It won't always be a good Section 19 case, and maybe that's going to impact the negotiation that parties are having. But at the end of the day, what the agency has over you is still the ability to bring suit, and you're going to spend a lot of money. And I feel like we have seen already, and I'm certain we will continue to see, instances where people are just going to bite the bullet and agree to give up the money under the pretense of a Section 19 violation, whether it's actually there or not. Now, one last point, Maneesha, sorry. As in all of these contexts, and as we saw with AMG in the context of 13B, we don't know when, but at some point, someone's going to say no, and they are going to fight it. And that's where the rubber is going to meet the road on the legal question.
And just to amplify what Noah said, I think that there have definitely been companies who have settled, but I think the calculus for settlement is also changing. So a company might say, "What? I'll agree to this. I'll pay some monetary redress, and I'll be done with it." But I think some of the things that are coming out from the FTC, the numerous demand letters following a settlement, the meta matter, the order to show cause, and reopening a signed settlement. So I think we have clients who are asking us, "Hey, what is the benefit of settling here if we're going to have this lifelong relationship with the FTC?" And so I think the calculus is changing somewhat.
I think that's absolutely right.
I suspect I'm not alone in this experience after AMG came down and getting calls from all nooks and crannies of clients and other stakeholders at the FTC about, is Congress going to fix this? Is there going to be a legislative fix that's going to put AMG essentially off the books and reinstate the FTC's authority in a way that was akin to the way 13B had been read by many appellate courts prior to 13B? We're 2 years post AMG now. Noah, would you be willing to share any thoughts about why a legislative fix hasn't gotten traction within the Hill? And I'll just ask the panelists in general, anybody willing to offer a guess about whether we'll see one going forward?
Look, I've spent time on the Hill, including publicly testifying about this issue, so I'm happy to share some thoughts. There's broad consensus for the notion that if someone is being defrauded, the U.S. federal government should have a role in getting that person's money back. No one disputes that proposition. And that, of course, that's the facts of the AMG case itself. But because, first, 13B is so open-ended if you include money, and critically because the agency is looking to condemn so much more conduct than that where paying people back is the obvious remedy. In particular, areas where harms are not well established. We have long left the day when thinking carefully about paying people back and the amount of harm was something the agency was struggling with. That is not a tether on today's commissioners. And so I think that the signal the agency is sending to Congress is, we're not going to tell you where this ends. We're not going to tell you how much people are going to be paying. Please give us all the authority that we thought we had back. I just don't know that flies. That's not what the members of Congress, or at least all the members of Congress that you would need to get legislation done, are saying. However, I do think the more you can ground a legislative fix and additional power for the agency on what had been the traditional aim of Section 13B enforcement authority, I think the more comfortable people are and the more likely a legislative fix is to happen. And just to be clear, I think there should be a legislative fix. I think there's a real need here to what Anant was starting with. There are people who are being deprived of earnings, right? Money they need to feed their families, and it's being stolen it's going to be very hard to find people who don't think that that's what should happen.
I think I might take a little bit more of a cynical view here. which is that I think Noah has very artfully drawn the lines around the merits of the legislation. But I just feel like, and maybe this is too simplistic to say, but Congress can't get its act together on a bipartisan issue or on many bipartisan issues. And so the idea, I think there used to be a thought at the FTC that it's okay to litigate and lose, because if you litigate and lose, Congress will step in. But I think what we're seeing with today's Congress is that that's just not the case. And so I'm just skeptical that there'll be any solution on this. I'm skeptical there'll be a federal law on privacy. I think it's going to be done at the state level. And so I think that's kind of a dim view of Congress, but I think it's realistic.
So I was a staffer on Senate Judiciary Committee when the FTC came in at one point to explain what would happen if they lost this 13B authority. And immediately afterwards, staff all kind of got together in this little small room off to the side to talk about, well, what would a legislative fix look like? And without betraying any confidences, it did break down along party lines. And I just think that in an era of divided government and with Republicans taking an increasingly skeptical view of the current direction of enforcement, I think finding a bipartisan fix when you have a divided government is going to be challenging. So, Rich, it seems like a better title for this episode might be The Rise and Fall and Rebirth of the FTC's Monetary Remedies Authority. What are the key takeaways here for practitioners?
I like that. I'm always in favor of an improved title. Got to grab people's attention out of the gate. I'm going to run through my takeaways, and I would welcome others as jumping in here too. I think the first one is that AMG was a big deal. The 13B pathway was significant for the FTC. It wasn't random that the vast majority of consumer protection cases where a monetary remedy was obtained went through the 13B path for the 30 years before AMG was decided. The second takeaway is that 13B may be dead under AMG and the lack of a legislative fix, but the Commission is doing a remarkable job of filling the gap. They have leveraged a host of tools. Maneesha outlined them as articulately as anyone I've heard. But the punchline is that there aren't very many situations where there isn't a avenue for the Commission to creatively seek a monetary remedy where there's a monetary harm. Now, takeaway number 3 is that the fireworks are still coming. Which of those paths are going to be accepted by the courts is a very, very open question. Broad interpretations of existing statutes and rules. Courts may very well take a cynical view of that. Rulemaking, the processes around the validity of any particular effort, whether they are successful in moving through the long, extensive Magnuson-Moss process, those overhangs are very much alive. And Section 19, but based on my research, which every one of our listeners should certainly double check, no one has taken a shot at Section 19 since the 1980s. And there was a mixed record of the Commission, even in that era. So whether that path will hold up in any given situation remains to be seen. Finally, for people that know me, they know I have about as much business predicting lottery winners as I do legislative outcomes. But I do think we have consensus across our group here today that a legislative fix is not in the near-term horizon. It may be a very long time before Congress looks at the FTC's authority and extends a new statutory basis to seek monetary remedies or otherwise alter the agency's authority.
Well, thank you, Rich, Noah, Maneesha, and Ioana for this terrific discussion on the future of the FTC's monetary remedy toolkit. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.